For landlords, screening tenants seems routine. But one small mistake can lead to a major lawsuit. Think a no criminal record policy is smart? That blanket ban can violate fair housing laws. Even a high credit score minimum can be illegal if it disproportionately affects a protected group. The biggest trigger for lawsuits isn't malice, it's inconsistency. This is a huge red flag for regulators. We're breaking down the top mistakes landlords make and giving you a framework to screen tenants legally. So, where do we start? You must know the protected classes. Federally, that's race, religion, sex, disability, and more. But local laws can add others. This means you cannot ask about these traits on your application. A casual question about kids can be used as evidence of discriminatory intent. Next, the Fair Credit Reporting Act. Before you run any background check, you need one thing: explicit written consent. A verbal okay is not enough. If you deny an applicant based on their report, you must provide an adverse action notice. This letter explains why and is not optional. Underpinning everything is documentation. Without a written record of your criteria and decisions, you have no way to defend yourself against a discrimination claim. Okay, you know the basic rules, but to truly stay safe, you need to understand the legal concepts that trip up even experienced property managers. Let's revisit that blanket ban on criminal records. Why is it illegal? The concept is disparate impact. A neutral policy can be discriminatory. Because certain groups are arrested at higher rates, a ban on any arrest record has a disparate impact. You must do an individualized assessment of the crime. Now, why is the FCRA so strict about notices? Because tenant screening reports are often full of errors. The government is well aware of this fact. Your screening company might mix up files or misreport crimes. As the landlord, you can be liable for using that inaccurate data to deny someone. Think about your current process. Are you just accepting a report without a second thought? Now let's see how these rules play out right here in Texas. Here's a big one for Texas landlords: source of income. You cannot deny an applicant just because they use a housing voucher to pay rent in some Texas cities. Cities like Dallas have source of income protections that cover housing benefits, including those for veterans. Ignoring local ordinances is a fast track to a legal fight, but another Texas law trips up landlords before the background check. What's the one document you must give every applicant before taking their application fee? If you fail to provide this document and deny the applicant, you may have to refund the fee and could face other penalties. It's a simple step that many miss. These state laws are clear-cut. But the environment is getting more complicated. Let's look at two emerging risk areas: technology and eviction records. Many landlords use AI-powered screening tools, but these algorithms can have biases baked in, creating a disparate impact on a massive scale. What about past evictions? A clear no, right? Not so fast. Rejecting someone for an eviction filing, if the case was dismissed, can be discriminatory. These nuances are where inconsistency becomes so dangerous. If you overlook a filing for one applicant but not another, you're creating a record of potential bias. So you have federal laws, state rules, and new tech creating a web of liability. How do all these pieces connect to either sink you or save you in a legal dispute? Let's connect the dots. Inconsistency is the #1 trigger, and poor documentation leaves you defenseless. Without a written policy, your defense is just your word. Now add in bad data. You deny someone based on a faulty report. Because you skipped the adverse action notice, they couldn't fix the error. You are now liable. And that Texas-specific document? It's your written tenant selection criteria. You must provide it before taking their fee. This is your first line of defense. A consistent written process isn't just bureaucracy. It's your legal shield. It protects you from claims of bias and proves you comply with the law. The common mistakes landlords make in screening are not simple. They are significant legal risks that can lead to devastating lawsuits, fines, and reputation damage. You must handle the complexities of fair housing and disparate impact. You must comply with every step of the FCRA, and you must follow Texas-specific laws. Your most critical action is this: create a written, detailed set of screening criteria. Base it on legitimate business factors like credit and income verification. Then apply those criteria to every single applicant, without exception. Document every step. This is how you move from being vulnerable to being secure. Proper tenant screening is not about finding reasons to say no. It's about having a fair, legal, and defensible process to find the right person to say yes to. Protect your investment and your integrity. The easiest fix? Work with a team that handles it all.